All right, so the recording is going. This is the September 8th meeting of the Post-Conviction Relief Work Group. We've added Colin Reingold to our illustrious ranks. Colin is going to be taking over the running of the work group for Kevin and I will continue to serve as backup for Colin as needed. We have Meg and Ed with us, so I don't know exactly where we want to start. Colin, do you have anything you want to start with?
No, I don't know. I watched the last work group that was posted, but I don't know what, if any, work was done since that one. That one was a while ago. So I was planning to defer to you and Kevin today, and pick it up next time.
Okay.
Uh,
I don't think there was any, and you guys can correct me if my memory's off, but I don't think there was any substantive work that we've done since the last time we got together. There were some scheduling hang-ups, but I think that we are still on the review of the Oregon, the OSB standards. And we were talking about client communication, I think. It's the
When was
last topic we covered.
When was our last meeting?
Back in July.
Okay.
I think, Colin, do you have the date on that?
well, there was nothing posted in July. So I think the meeting before that was, I think, June.
Okay.
But so that's why I wasn't sure if there was something missing or if there was just a scheduling challenge.
June sounds right.
I've got the 14th of July listed for meetings, but I was not there, and I remember there were some scheduling issues that kind of passed by me, but the 14th I did have on calendar.
I think maybe there was one that was going to happen, and then I was the only person that showed up. So we decided to just reschedule.
Yeah, that sounds right. All right. So then I think the best place for us to go next is I will share my screen. So we've got the sorry, I'm going to talk and then do things. I'll share my screen so we've got the latest working draft notes up between us, and then we can pick that up. Let's run back through the client communication section, which is the most recent section we've done, just to make sure there's nothing we're missing, and then we'll figure out maybe go on to hearing prep or something like that from there. Okay. Everybody see that okay, or does it need to be bigger?
That's good.
Cool. All right. So we've got a note on when the first time to get in touch with clients might be. Anybody have any other input on that? Other than what we have? Get in touch with people as soon as possible. But it sounds like within at least 14 days for in custody. Or 30 days.
Do we, let's see, sorry, I'm just looking at the subparts. Yeah, I think I agree with what's there in the subs A and B.
Okay. Meg, anything to?
Just reading through. I don't think so. That looks good.
Sure. If you guys have anything to add on the routine contact or the need for in-person contact notes, we can fly through those.
I don't know if we want to sort of annotate, for lack of a better word. I think there is a UTCR on 2C. I don't know if we want to include that, but I think that is addressed if, and there is, I know at least Umatilla has a local rule on church motions, timing of church motions. So yeah, I don't know if we want to include that kind of stuff, but I can certainly put some of those together if we want to add it.
That
Yeah,
would be
maybe
real
just
helpful.
like checking some kind of rule about checking for local rules on the deadlines for church motions and informing clients of those.
Great. Okay. Anything else in 2 before we move on to 3?
As far as D, I'll just know I took something. Actually, I took a subpoena today to the post office, and they told me it wasn't going to get to Portland until Thursday. Where it says D, provide client copy of trial memorandum on the date as filed. I certainly try to mail it on that day, but I mean nobody's getting those.
And yeah,
You know, hopefully if they get it same week. So I don't know.
Okay. Anything else?
Are we still going through the other sub parts of the OSB communication standard, or is it? I guess I wasn't sure if we were still doing that, or if the next thing after what's on screen is to move on to investigation.
I think we can do either.
I guess, sorry, I guess having not been here and not watched all the previous work groups, there are other things in the OSB standards that looks like that we haven't talked about, and I wasn't sure if that meant we were leaving them as is or not including them, or what the relationship is between these notes and the existing OSB standards.
That is a good question, and I don't have a great answer for it. I'm picking the notes up from Kevin.
Yeah. So and the example I'm looking at is the OSB sub 6 is advise the client about what happens if they'd taken a plea before and went on post conviction and could get more serious consequences according to the standard, which we haven't addressed here. And I don't know if it needs to be updated and whether or not it should be included.
Thank you for bringing that up. My recollection from before the previous meetings, there were a few areas in the OSB that we thought would fall into a different section, but I think we were, we were generally inclusive of those. So it may just be a gap where we left off, unless we were, thinking maybe this fits into a different section.
Yeah, I suspect that's going to be a gap where we left off. But let's do this. Let's take at least a minute. We've got big categories. We've got the role of counsel. We've got client communication so far, and we've got a section for an amended petition and a section for trial. Let me do this.
Well, I think the amended petition and trial were subparts of communication. Well, I think that, well, I
Let's
don't think
assume
they
they're
were.
not.
Okay.
I just think from a drafting standpoint, and I guess Colin, you'll be doing the drafting, so you can tell me, final call on that. But I think from a drafting perspective and thinking about the standards we've done and presented so far, those kind of things would be our big chapter heading type items. I mean, there's what to do in trial, what to do with the amended petitions, what to do in preparation for trial, and that sort. Does that sound right?
Well, that's a deviation from the OSB standards.
Yes.
Is that intentional or is just how it's developing?
Both. I think I would be comfortable deviating from the OSB standards, so formatting, so long as we've got the information in it, the same information in there, to kind of align the formatting between the standards that we're putting out in criminal delinquency and the other dependency and the other quasi-criminal stuff.
And I think I don't, Jordan, not to exclude anything from the OSB, but was it the Montana or one of the others that was pretty thorough? I think maybe we were outlining from one of the others that was pretty thorough.
Yeah, I think it may have been
again,
Montana,
not to exclusion of OSB, but I think our order may have been
maybe not.
tracking one of those other standards.
That sounds right. Although looking through the material, it looks like there's a Montana set and a Washington standard that we've been looking at. But the Montana one is fairly thorough. So, assuming for the moment that we are not bound by anything in particular, what other big section heading do you guys think we should have, and what else is important to know in the PCR practice?
So I'm only seeing the one page that is up. I heard Colin mention that the investigation part, but I don't see it.
Yeah, investigation is next in the OSB standards, and I would think I practiced post-conviction in Louisiana for a number of years, but I haven't practiced here. But presuming there's a fair amount of similarity, I would think investigation ought to be its own standard.
Yeah, I mean, I would say most of the cases I have, it's more investigatory. We use transcript. I use deposition transcripts way more than trial testimony, and so trials. Most of my cases is more like a summary judgment hearing than it is like a criminal trial.
Interesting. I think I've said before, but I'll say again just in case. Thankfully, I've never gone through the PCR process in any capacity. That is interesting.
Yeah, it's kind of an interesting time. There's some new judges coming in, and it's a little, you had 2 or 3 judges that did all the cases for a long period of time, and some new ones coming in, and I think they're a little, or they're quite aware of how the Court of Appeals has been changing, but I don't know what kind of differences we'll see.
Okay, so I just popped in the big picture or the big categories from the OSB standards. You got, well, it says independent investigation. Oops, wrong window. Independent investigation. So we have communication with clients, role of counsel. Independent investigation, asserting legal claims, litigating claims, and obligations of counsel after trial. Other than those kind of section headings, are there any other big areas that you all think we should include?
I wonder if I'd be interested in Meg's perspective, what she sees in reviewing, records and transcripts. I wonder if we would want a section on basically on church motions, or not just client communication working with the client, but actual formalities. Like I have clients who just, it seems like they have their calendar marked to bring church motions, and there's sort of that there's a depth of litigation that could be adversarial to the client that you're just sort of kind of trying to avoid. That might be worth a section on. I don't know.
Yeah, I mean, I think that's reasonable. I don't think it's going to be a very long section. Like, I think it's pretty short. We don't have much from the courts about what you're actually supposed to do, and it's kind of conflicting. So it might, yeah, but I think a little bit about avoiding taking an adversarial position would probably be a good idea.
Yeah, we could sum up what not to do pretty quickly and similarly, but I almost wonder just even sort of a section of us, sort of proceeding from the beginning of a case, being aware how church motions and issues may come up. I mean, they're supposed to come up, but certainly at the time of filing the pleading, which is what we've included here. But I have one that it's coming up when trial memos are being filed at trial, just kind of a constant. And I don't think.
Yeah, I think there's a lot of
criminal practice prepares you for it.
Right. Yeah. I think there's a lot of confusion for petitioners about how they're supposed to do it because they're basically navigating it by themselves. And I think if we could provide, I don't know how this document is going to be used by practitioners, but just some like guidance about kind of what the idea is, and like the more you can provide information and guidance on how to do a church motion, let's just like the logistics of a church motion, I think could probably avoid a lot of problems, both with like client relationships and then just like issues on appeal and that kind of thing. I think a lot of it is, clients just wanting to make sure that they're having a chance to have their issues raised, and when that goes wrong at the trial level, and they can be very reasonable, like frustrated, at the appeal stage, to learn that those claims are all now completely waived and there really isn't a way to do anything about that. And so I'm not sure the trial level PCR attorneys totally understand how that process fits into post-conviction. I mean, I'm sure some of them do, obviously, like Ed does, obviously, but it seems like from reviewing records that some folks aren't as like sure what to do with that.
And maybe even just at the advice stage with clients, because I have clients, I mean, they're sending all kinds of things to the court. They're even sending in clemency things. I'm saying, hey, we're preparing for trial. Let's keep our statements managed. Let's keep an eye on this. I'm going to put you on the stand, and they're going to have a notebook of stuff. So, but yeah, I learned that basically the hard way. I'm I'm getting contacted by DAs about SB 819 petitions, and clemency stuff is coming, and they're sending stuff to the court. And maybe, yeah, it's sort of an introductory with counsel. Be aware of this, and encourage your client to work with you on all those things. I don't know. Sometimes the clients have a sense, I think, that the judge is going to advocate for them or help them, and it's messy.
Yeah.
Okay. I think we could probably do some of that. I don't think we'll get to the point where this is a practical guide to how to do it. But we could have requirements that people need to know how to do that and do it when appropriate. And then as we go down the road and we get more into the training aspect of those, we can create that kind of practical guide and trainings on how to do it.
Sure.
Assuming we get into that.
Yeah. How do you envision this document being used? Like, practitioners get it when they get a contract and like have to commit to following it. How does it work practically?
I'm gonna let Colin answer that if he wants. He's been doing a lot of writing on what that means.
Have I?
Haven't you?
I don't know that I have. I think it is, yes, Meg, I think the idea is that they are referenced in the contract and contractors agree to adhere to the standards, and then the agency uses the standards to, if someone's not meeting black letter, then we might get a complaint about it, and then we have to investigate the complaint and see what we can do about improving that practice. And then if it's a best practice that people aren't doing, then those are areas that we could use to identify, not this is more aspirational, but we would use it to identify where we could do trainings, or in the future in a different resource environment, how we can apply resources differently to raise the level of practice if there are best practices that are consistently people say they can't achieve for one reason or another. So I think it's kind of twofold. It is largely important for practitioners to be aware of, but I think, and Jordan, correct me if I'm wrong, I think in terms of that, its day-to-day usefulness, it'll be more useful for the agency in the immediate than, as opposed to being like a guide for practitioners. Does that seem fair, Jordan?
I think so. I mean, I think it'll be useful to practitioners who are starting out or relatively new to get kind of a floor for what this has to be. I mean, my background is in the criminal defense work in that context, so that drives a lot of my analogies. But things like you have to visit your client if they're in custody within 24 hours of your appointment. That is kind of a base standard for what you need to do to be able to say, yes, I am meeting the bare minimum practice of criminal defense work. You have to visit your client within 24 hours. And in that first visit, you should start covering, X, Y, and Z with them. You should start building relationships this way. That other stuff is all good to know, and it's real good to do, and it will help you down the line. But it's not the requirement, if that makes sense. I don't know if that helps at all, but that's the best analogy I got.
And part of the idea with this of like redoing these, because we have, I think Kevin said before, that the OSB standards are currently like incorporated into the contract.
Mm-hmm.
So we're like rewriting them to kind of simplify and make it enforcement easier, clearer.
Kind Couple of reasons. One is because the legislature told us we had to. They directed the agency to create its own guidelines and best practices and standards for work.
Right.
Two, because the OSB guidelines are from what, like 2010, maybe? Can't remember when they were last updated, but they're not recent. So we want to make sure that we have up to date standards that are workable, and because we want to make sure that the people doing the work and who are actually, providing the representation have some say in how we're gonna be evaluating the representation that's given. I mean, I could read the OSB standards and write them, but they wouldn't be as good as what you guys are coming up with.
Okay. The OSB standards seem very thorough to me and
Okay.
good, but also a lot of kind of the more best practice aspirational stuff.
Okay.
So I guess, and it doesn't seem like they are effectively achieving like representation at this level.
Mhm.
I don't know. So it seems like simplifying it could be helpful as far as like making things clearer and more enforcement a little easier.
Great.
Oh, important, but I don't know if that's the right approach or not.
I think so.
Okay.
Yeah, I guess just to put a finer point on it, because the OSB standards are so thorough, and maybe this is exactly what you were saying, Meg.
Yeah.
It's hard for the agency to say, because and because implementation is a weird word that modifies the standard. It's hard for the agency to come in and say, well, you're not doing all of this.
Mm-hmm.
So what are we going to, what action is the agency going to take? And so if we set it up as black letter and best practices, then it does become a little bit easier to know what the minimum at least is, which is, I think, harder to do with the OSB standards.
Mm-hmm. That makes sense. Okay. Well, with that in mind, is there anything left in the communication section from the OSB that like seems like it ought to be black letter? I haven't looked through it all.
You want me to pull that?
I think the only two things left were the one I mentioned earlier about advising clients about risks if they had previously taken a plea, which was listed as an implementation. And I don't know if that should still be included or should be a best practice. And then the other one was about just communication generally about developments in the case.
I think that's really important. I mean, I've had a bunch of clients in the last year or two that really, I don't know, they think they're filing like a motion to modify a judgment. They're very confused on what post conviction is or isn't. And yeah, it was, and I guess sort of I think Ramos played a big factor in who and when people were filing post convictions. But I had to learn that of making sure, especially in the case of a plea, okay, you understand what we can and can't do in post conviction. So I do think that's no reason to exclude that, I guess.
Okay. Colin, what was the second thing you had? Risks to client.
This is numbers like 5 and 6.
Yeah, number 5 is just counsel should keep the client informed about progress of the investigation, development of the claims. It's more of just like a catch-all, talk to the client periodically, which maybe is already covered, but is separately enumerated in the OSB standards.
Okay.
Kind of separate from meet them relatively early, and also separate from meet them before trial. Talk to them in between too, sometimes. Seems to be the point of number 5.
So then, do we see value in calling out these sections independently, or should we leave them under litigating claims? Or put them under litigating claims, I guess.
I don't have a problem with having them under litigating claims the way they were under the OSB, but if we are kind of trying to simplify and emphasize things, it might be better to have these like separate sections, really call out as opposed to the complexity of the OSB standard.
I haven't read I haven't read ahead essentially because this is a new thing for me here. But is asserting legal claims
That seems like
just the amended petition and then litigating the claims the trial? Are we just calling them something different?
Yeah, I
haven't
think asserting will be your
Yeah.
pleading, but litigating will be,
like presenting
I mean,
evidence.
I use every type of civil discovery, so more than just we think of trial in the criminal context. But yeah, I think asserting is just pleading.
Mm-hmm.
Okay. So then let's talk about the section on church motions, and then we can just keep following that outline down. What do we want to make sure is kind of baseline law with the church motions?
And so I wonder if I don't want to muddle us up, but I know we were referred previously to familiarity with local rules and various rules. I don't know if we'd want to have that also in a church section, but because I think I like how Meg suggested, like being familiar with, this may be somewhere we can say, be familiar and aware of, client, the situation clients are put in, that they don't have any remedy against you for your representation. The court tells them, you better just make sure you bring it to the court's attention. And that's your only approach.
Mm-hmm. Okay.
I think, yeah, like explaining how to raise a church motion, which would include like format, timeline, any deadlines. And what a church motion is, explaining what a church motion is asking for. Which is, order my attorney to raise these claims or replace my attorney. Or proceed pro se, I guess, is the other option.
And it seems to be, I see the same format over and over. I think there's a form in the law library, and it essentially is like church and disqualified counsel. I don't know if that's just a vice they're getting one by one, but it seems like something that's available that they're lumping together disqualifier with have counsel withdraw and a church and all this kind of stuff. But like you said, Meg, it really is pretty limited to what what church actually is.
Yeah. And then I think the only other thing is just at the church hearing or in response to the church motion, whether that's a written filing or at a hearing, that counsel should not take a position adversarial to the client, so shouldn't be arguing against like the merits of the client's claims. Shouldn't be arguing why those are bad claims. Like they can explain what they did to make their decision not to raise them, like what process they went through, but I would say that that's as much as you should do. I think the
think
court
there's a
you can do a little bit more than that. So maybe yeah.
there's a sentence or two. I think it's in the bar books. I think there's a sentence or two in the bar books. I want to say the case is Lopez, but that's kind of like there's a really good go-to in the bar book that I can pull out, but it's pretty concise. I think it's pretty on point of what not to do in the church hearing.
Yeah. Anything else for our church motions section?
I can't think of anything else. I think we can include it in communication, sort of reminding the client to communicate with the lawyer and not the court and all these other people and all these other agencies.
Yeah, and the Lopez is, let me just pull that up. Lopez v. Newth 287 or app 731.
In USC?
What?
News?
Newth, N-O-O.
NOT.
Okay. And what was the site again, if you could make?
287 or app 731 from 2017. And it's Newth with an H after the T.
The italics in, so my LRW professor isn't mad at me. All right. So then let's get about 15 minutes left. I suppose I'll put it to you all. Do you want to move on to the investigation section, or do you want to take a bit of a break before we reconvene at 1 for the habeas group?
Ed, what do you want to do? Your call.
I'm okay to move on to investigation. I don't know what to suggest, but I'm good to move on.
Yeah,
All right. All right. So, suggestions for what to include in the investigation. What does a good investigation in a PCR case look like?
I mean, I think using subpoena power and deposition. I mean, it always amazes me what I can do in a PCR that I couldn't do in the criminal defense. So, obviously it's not but I think taking with the point of view that you can compel witnesses to talk to you. Victims can be a little less so, but yeah, I think it's like doing a full-throated investigation that you have the burden of proof, burden of production, burden of proof, and use discovery tools. I mean, obviously that may be getting ahead of yourself. What it says in the OSB is just using a qualified investigator. A qualified investigator may be able to rule out and direct some of that. But for me, like my investigations are you getting people who don't really want to cooperate and sit them down for deposition and, make them produce things under subpoena.
Okay.
I think just like basics, getting like the trial attorney's file, the DA's file, the trial court file, the transcript of any proceedings. Those are kind of the starting points.
Okay. Anything else that you would get as a routine?
Assuming there was an appeal, I'm sorry, I
Oh,
don't
yeah.
I don't know if you said trial court file make, but assuming there was an appeal, the appellate court files are typically more, useful and instructive to me than anything in trial court file. And not as easy to get. Usually the transcripts I get from OPDC lawyers
Mm-hmm.
aren't what I'll get from the court. I oftentimes like to get the transcript from the court rather than what I get. And some of those things I think we had talked about. I don't know if it's on here, but we had talked about, voir dire is never transcribed that I've seen. Obviously we can get it. We can get the audio and get it transcribed, but that certainly you can find out an investigation. For starters, you're not going to know. I don't think you're not going to know if there were bats and challenges because it's not transcribed. So that may be a question for trial counsel. Hey, what and that won't necessarily answer the question, but if you don't ask trial counsel, you won't even know, were there issues during voir dire.
Yeah, an appellate counsel file is probably that file would be important too.
Okay.
I like what that subsection 2 in the OSB says. I moved away from it. It talked about using experts and
Counsel should seek the assistance of qualified investigators and expert witnesses where necessary for investigation, preparation, and presentation of the case.
I mean, I think so, because there is a lot of times there's a lot of forensic things that are overlooked and it might be useful.
Yeah, and did you include the appellate counsel's file as well?
Yep.
Okay.
Wait.
Or the appellate court file, but the appellate attorney's file too.
Okay. Anything else must do as far as investigation goes?
I guess one of the things I'm seeing, and this probably isn't typical in PCR practice, but with the Ramos, some of these really old cases,
Mm-hmm.
we're running into counsel being retired, just a big huge runaround with getting files. And would we want to say something about how far you should go or be willing to go to get files and records from previous counsel? Maybe more detail than what we want here.
I don't know. How far do you think people should be willing to go to get the information?
I'm dealing with it on a case by case basis. I mean, I had a case where I had to file a bar complaint against counsel, but it was he actually told an investigator he'd already given me the file, and that really concerned me, made me very worried. But that got played out with the state bar because the guy was looking for his file, couldn't find it, and then tell somebody he gave it to me, and it was a death penalty case.
Oh.
Mhm.
I mean, Ramos cases are the ones that comes up the most with, but there are other cases where that could come up too. So, especially, yeah,
Like-
like something like a death penalty case that can be ongoing for, many, many years before it actually gets to post-conviction.
I mean, I'll give you another example. I have one where counsel's out of state. If I wanted to, I could probably force him to a deposition. I'd have to get a foreign subpoena, do all this stuff, do all those things, and it's only the client had other counsel for a motion for new trial and on appeal. So he's given me a lot of files, but he just said, "Hey, I can't guarantee this is all trial counsel's files. You might want to check with him." And now he's out of state and not really helping. And I don't think I'm gonna take him to into a foreign deposition. But it would obviously be different if I didn't have all these other files from the successor counsel who did motion for new trial and an appeal.
Mhm.
Maybe that
Okay.
could just be like a familiarity with, or like maybe not even familiarity with, but just an understanding that you might need to go to certain lengths to get get these difficult files. Like, I mean, I don't think they can, I don't think an attorney can just decide not to get the trial attorney's file because it's not, readily provided, right? You have to get it.
And we can leave it there for the day too, and hopefully get Ginger's input because she's been through this way more times than me and probably has some good insight too.
That's true. Yeah. Yeah. Good point.
Yeah, that sounds like as good a place to leave it as we're gonna find shortly, and we can always revisit this stuff and recap next time. So I am going to cut our recording here, and I'll see most of you in a few minutes for the habeas meeting.
All right. That's good.
Thanks so much. Good to meet you, Colin.